Hi, everyone. I'm immigration lawyer John Khosravi. Thank you for joining us again today, May 5th, Wednesday, 5 p.m. Pacific time, here to take your questions, live general education questions about U.S. immigration and talk about what's going on, all the changes, everything that pops up. Just shoot them right here on YouTube, on Facebook, on LinkedIn, on TikTok, all these different platforms. We're there for you. I just want to let you know that we are still doing our free consultation raffle, which means that if you're watching this, especially on YouTube, you like, comment, and you get chosen every 10 minutes. We'll choose one person to do a free 15-minute consultation to talk about your case and see what's going on, see if we can be of any help. You just got to watch, and when your name is called, I'll give you instructions. Take a screenshot to prove that the comment that you left was your comment, and then email it to me at info@jqqlaw.com, and there I'll check it out and I'll send you an email to schedule a consultation. There'll be a link for you to do a video consultation by Zoom, or if you needed a phone call if you can't set up the camera. But I think it's gonna be fun doing that. So hey, with that, let's get it started. And we got our first comment. Maddie Guerin says, hey to you too. Thank you for joining us. And we're gonna jump to your questions. You know, this week has been a traditional wild week. You know, India, where it has had a lot of backups, and it's gotten even worse because of the shutdowns, getting exceptions to the travel ban, the COVID travel ban, the NIE, the national, national interest exemptions, or whatever they're called. Those have gotten more stringent and more difficult to get. It's been a real nightmare. But hey, we gotta do what we gotta do. So Bud asked, what's the news on updates on K1 fiance visas? Well, one of them was that essentially there are going to be exceptions for the K1, but hey, who knows when that's going to happen? But they're going to give them priority to get those in and start doing interviews. But we have no idea when it actually practically is going to happen because each embassy makes those decisions on its own. We have a question here. What is the I-824? This is something that's really important that pops up and a lot of people aren't familiar with. When you start an immigration case and say, hey, I want to, for example, do it in the United States. So I'm going to apply for adjustment of status, a green card in the United States, but you ended up having to leave the United States. Well, you got to have the file transferred overseas. And so for the government to do that, you have to submit Form I-824 to tell them that once this I-130 is approved, send the case out to the embassy for consular processing. Unfortunately, this I-824 costs money, and it takes an unknown amount of time. If you look at processing times on USCIS, sometimes it says it takes 10 years to do this. It's kind of ridiculous. It doesn't take 10 years, but sometimes it takes a year or two. So, you really have to plan ahead of time about what you're going to do about your case, because you want to avoid at all costs having to do a Form I-824, not only because of the cost of money to filing for it, but also because, more importantly, the massive delays with using such a form. So I really recommend avoiding that to the extent that you can. Karandi Bass, hi sir, would you be able to apply for a driver's license in California with just the worker permit? Well, if you have a valid work permit, that could be used as part of the process for getting a driver's license in California. It depends on who you're dealing with at the Department of Motor Vehicles, the DMV. That office, every time you go there, you do something differently. But the work permit itself, if it's properly in the system where the DMV can connect with USCIS, then it's possible, but it depends on your status, what kind of work permit it is, what your background is. There's a lot of different things that go into this. So, I can't say for sure it's going to happen. That's why I say you got to check it out. First of all, go talk with the lawyer about your case to see what the situation is. But secondly, it's up to the DMV officers and how strict they want to be. Remy asks, we had our green card interview on April 5th, and the officer asked to submit a document. We went to the same field office and submitted the document, the same officer he collected. And I'm guessing you're saying nothing's happened yet. Well, usually you want to mail this stuff in rather than collecting it. It's more official that way to go through the mailroom. But, it's up to the officer what they want to do and how soon they want to connect with you. So, unfortunately, there's not much more I can add to that. Kishore asks, hi, my I-485, that's the application for adjustment of status. Green card filed in October and date is current in January, but I still have not received medical RFE. Is there any advice like raising service requests? Well, Kishore, it's perfectly normal to not have received the RFE for the medical request by now. There's no reason to want to do a service request. It's kind of premature. Just wait, and it's going to come. Timelines with immigration are slower. So just because you're current in January doesn't mean that things will start popping and happening that fast. Now, we're getting our typical questions about how long it takes for a case, when's the embassy going to open up. I don't have answers for these, just as I don't have an answer for when the COVID pandemic is going to end. It's up to the embassy, it's up to the field office, it's up to USCIS and government when they're going to process your case, when their biometrics are going to be sent, when their appointments or interviews or whatever is going to happen. You can check out USCIS.gov for their estimated processing times, but they're not reliable. Unless they're really out of whack, maybe you can file a lawsuit or a complaint. But other than that, you have to be patient. Now, I do want to remind people that if you are interested in a fiance or marriage green card case, I've written the Ultimate Marriage Guide. It's an ebook that breaks down the whole process and gives you a great idea of how to develop a strategy for a case before you consult with an immigration attorney. It's the best out there. All you got to do for free, download at www.marriageimmigrationlaw.com. Again, that's marriageimmigrationlaw.com, the Ultimate Marriage Green Card Guide. I think you'll really enjoy it. It's the best one out there, in my opinion, and I wrote it. So let's go back to questions. Levi asks, I'm close to being a citizen. Well, great. I filed my I-130 for my wife. Once I'm a citizen, what form or what process is it to update my I-130 for a green card petitioner to a U.S. citizen petitioner? Well, the process is that just sending a letter with evidence that you're a citizen, your naturalization certificate, to USCIS with a copy of your receipt so they could connect the I-130 that was filed by an LPR, green card holder, and connect that you're a citizen. Now, it shouldn't really make a difference in your case from my experience. One is I've done this before where even though we mailed it to them, we have to call them 3 or 4 times until they understood it. But even with that, it didn't make a difference in our timelines. But who knows? It may be different this time around. Might as well do it. Noor asks, hello, I'm waiting for my I-129. That's a work, I-129 is a work visa. I'm a work visa, non-immigrant visa. Non-pro-tonque, which means they're trying to fix it up, an error that happened. I leave the U.S. now without waiting for a decision. What happens to my petition? Will it get rejected automatically? Yeah, if you have a change of status case pending, and you leave while it's pending, it's going to get rejected automatically for abandonment. If it's an extension of status, they play it differently each time, but probably it'll keep going. But it's not pro-tonque, so you're already asking for a lot. We'll see what actually happens with that case. Kishore says, thank you so much. Thank you, Kishore. I appreciate that. Raquel says, is watching with you from Tanao City, Batangas, Philippines. Amazing morning, everyone. Well, thank you, Raquel. We have a lot of people from the Philippines, actually. My team, most of it is in the Philippines too, and they're watching here as well. Hey team, Kayla and Lawrence, how far do you guys live from Tanao City, Batangas, Philippines? You might have neighbors. Now, while I get back from them, I want to remind everybody we are doing the free immigration consultations, 15 minutes as a raffle. Just comment that you'd like to have a free consultation, like and comment on wherever you're watching, and my team will pick somebody and I'll say their names probably in a few minutes. And if you're watching, if you hear it, take a screenshot to prove that it's your profile that posted that comment, and just email it to me at info@jqqlaw.com. That's my work email, info@jqqlaw.com, and I'll send you a link if you're the winner to schedule that consultation. All right, Remy asks, I learned from USCIS website that for category C9, the EADAP renewal will automatically extend for 108 days. Does that mean extend 180 after the package? Okay, I'll break that down. So if you have a green card case pending and you apply for a work permit with that, the employment authorization document, the C9 category, if your work permit, that employment authorization document is about to expire or within 6 months of expiring and you file renewal, you automatically get 180 days from the expiration of that card to hold you over. Now, it's just for the EAD, not the AP. The advanced parole, the trial permission is separate, and that is not automatic. It's just 180 days automatic from once they receive it and you get the receipt, that receipt will be a 180-day extension from the time the existing employment authorization work permit document is going to expire. Hopefully I said that a little fast. Hopefully it came through, but thank you for your question, Ramya. Monsfaz, can I file to vacate my removal order since I have removal order from 2015? Also, I do have TPS. Monsfaz, that's a deep question. You should really consult with immigration in private. I don't handle removal cases, so I'm not a good resource for that. Again, I want to remind everybody about these timelines. I don't have any power over your timelines. It's really up to the government how long they're going to take with this kind of stuff. Alicia asks, I filed my AOS, my adjustment of status case in March 21st, 2001. Application as rejected due to wrong address, lawyer mistake. Refiled April 21st. You're saying 2001? Maybe it's a typo here. Maybe 2021 you mean. But my I-94 expired April 30th. Do I need to file a waiver due to expired 94? Well, a waiver won't do anything in that kind of case. Ali, it depends on what your adjustment of status is based on. If it's based on being married to a U.S. citizen, then no. But if it's based on being married to a green card holder, your I-94 expired, it could be a problem. It's not a waiver you'd file. Maybe it gets really complex. So if you're married to a U.S. citizen, it doesn't matter. If you're doing employment-based EB1, 2, or 3, it doesn't matter as well. But if it's other categories, you've got to consult with the attorney in private to see how to deal with that if possible. Hopefully your case is okay. You may have to leave and do consular processing. It's a deep analysis that has to happen. Okay, so Annie asks, if I'm from Honduras, can I travel to Mexico with no problem, or what do you recommend? So Annie, I'm a U.S. immigration attorney. I can't advise as to what Mexican rules and laws are, so sorry, I can't be of help. Rima says, thank you so much. You're welcome, Rima. And with that, actually, I want to name the raffle winner, Remja Raj. You're our raffle winner. Just take a quick screenshot of your comment right here. Email it to info@jqqlaw.com, and I'll send you a link to schedule the free 15-minute consultation so we can talk about your case and see what you can do. Noor Ahmed follows up. Thank you. Actually, it was an extension case, not change of status. So USCIS will still process the petition if I leave the U.S. without waiting for a decision. Please respond. So Noor, there's this memo that came out in 2001-ish, I think, or 1998, something like that, said if you have an extension of status case pending and you leave, that leaving will not lead to an abandonment of your case. Not every attorney agrees with this, but I think it's possible. But then again, you have a nunc-pro-tunc case. It's a little more deeper issues than that, and I need to know your whole case facts. So I can't say your case will happen like this because I don't know all the details and nuances of your case. Talk with your attorney about that. But in general, it is possible if you have an extension of status case pending for 9129 that it'll still be pending if you leave and come back. But there's a lot going on there that we have to analyze. So I can't say for sure that this would apply to your case. Alex asks, can you do the FD 258 fingerprint cards from I-75 live scan? No. For Form I-75 under rule of conditions, you have to do a biometrics appointment where you go to an ASC, a center for that. If they don't waive it for you, do it there. You can't go on your own and do the fingerprints and send it in. That's not how it works out. So unfortunately, you would not be able to do that. Sugar Love asks, hi, will DNA be accepted to prove that my sister and I are siblings? Thanks, have a good weekend. So, maybe, maybe not. It's up to the officer. You really want them to ask for DNA. You could submit it beforehand. But the way to prove your siblings is using your birth certificates and showing that you have a parent in common, all that kind of stuff. Just do it the proper way. That should be fine. If you don't have that documentation, it gets more complicated. DNA may be required, but that's the last resort. Nora Hamad says, thank you so much. Really appreciate it. Thank you so much as well. Thank you, Eric, for joining us. John asks, I filed my I-824 for an I-130 that was approved in 2016. So he filed that this case be sent to the embassy. And I-130 means the relative file for them was approved. I guess originally they said we're going to do the case in the U.S., but it was really going to be done the embassy. So they filed an I-824 to send the case out. And now I want to file an I-212 and a 601. Should I file the waivers 212-61 first before starting consular processing? So John, you have a really deep and complicated case. I can't really advise it here. For 601, you usually need to go to the interview, get denied, then file the 601, and you probably did 212 at the same time. But this is something you should consult with an immigration in private about. It's not something to talk about here. So that's that. Ali says, thank you very much. I appreciate it, but my son petitioned for me. Ali, I kind of lost track of what your question first started. Okay, see, I-94. Well, if your son's a U.S. citizen, which it has to be, then that's fine as well, Ali. So if your son's a U.S. citizen and they apply for their parent, you could be out of status and it's still fine. So that error the attorney made won't be a problem because your son's a U.S. citizen and you're adjusting status based on immediate relative status. So overstaying in that category is okay. Okay, so Shub asks, I got my status that fingerprints were taken, but I didn't go for any biometrics, so it's waived. Yeah, so if you're doing a I-751, which means removal conditions, you're filing that 2 years after you got your green card. You probably adjusted status in the United States, and they still have the fingerprints from that time, so they just use those again, and you don't need to do that, thankfully, and save you that time and hassle. But that is the case. As a quick reminder, we are doing our free 15-minute consultations. We already gave one away. We have two more, one at 20 minutes and one at the end of the show. We're going to name it off. Just put a comment, say like and comment on whatever platform you're watching, and then just say consultation. Take a screenshot once you're chosen, so I know it's your profile and also I'm faking it's you, and email it to me at info@jqqlaw once I name the raffle winner. And also the ultimate marriage green card guide for those who are interested in a marriage or a fiance case, and maybe anybody who's trying to go through the green card process. That really helps break down how the general system works for them too. Just go to www.marriageimmigrationlaw.com and download the Ultimate Marriage Green Card Guide. So Ram asks, my U.S. citizen son petitioned my adjustment of status on December 11, 2020 at the National Benefits Center. We got the receipt. Haven't heard anything after that. I'm on an L1A intercompany transfer. It's a business visa. Waiting for employment authorization, travel permission. Will the biometric suspension decision for L2 and H4 help speed up my case? No. Has no bearing on your adjustment of status case. The new decision that come out is going to be coming out officially that if you're doing an L2, a spouse of intercompany transfer, H4, spouse of a specialty worker, you don't need to do fingerprints. That will not affect an adjustment of status case. Now, if they, an L180, they don't have your fingerprints either. So it just, you got to wait. That's about it. Rafael says, I'm interested in a free consultation. Well, God bless you. Thank you so much. My associate will be naming off names in a moment, really in 6 minutes or 5 minutes or so of the hour to get our second raffle winner. But thanks for listening out. You're in the running. Thank you for posting that. So I guess I'll go and talk about this briefly. When Trump came, he added this requirement that if you're doing a spouse of or child of a person who has some sort of visa in the United States, you have to do a fingerprinting appointment. This was not the case before. So if you're doing H4, L2, O, whatever these other different categories for spouse and dependents, now you have to do fingerprinting. And it's been really bad because these spouses are taking over a year to get the biometrics and their work authorization going. So it's a major headache for these categories. And there's been lawsuits, and great colleagues of our at Watson Bannis, it's a great immigration litigation that keeps suing the government. They essentially won out where the government said we're not going to require biometrics fingerprinting appointments for the E category spouses, L2, H4, and I think just those three. Unfortunately, it wasn't wider than that. But it's great news because these people are going through a lot of hell to be able to just get things going. So I'm glad they're able to help them out and go through that. Fidus asks, what is a asylum work permit fee for the first time? I don't have that at the top of my head. It might even be waived, but go just check out Form I-765 and the form fees are all listed on there. The most updated ones, that's the place to go. Just go to USCIS.gov and catch it there. And we have another question about why asylum cases take so long. Because they do. You must have heard what's happening at the border. A lot of the asylum officers have to go to the border to check that out. Also, the number of asylum cases has, multiplied by 10 or 15 times what they were 10 years ago. So it's a difficult thing for it to all happen. And John says, thank you. You're welcome, John. Thank you for posting your question. The I-284 situation is a nightmare. And if you have to file waivers to 12601, that's not going to be a fun situation. So I'm going to take some time out while the questions are still coming in about a topic I've been wanting to talk about a while, because a lot of people contact me and say, I want to come to the United States. I want to immigrate. How could I immigrate? How could I live the better life in the United States? And I always back up and say, listen, although it's my job, it's my business to make money of helping people come here, I don't always think it's the best decision to do that. So the primary 3 ways I say people, or 3 or 4, to come here is this, because it's a really difficult thing to immigrate to the United States. Just immigrate in general. You can move your house from one state to another is a headache, let alone to another country, which may have a different language, a different culture, a different attitude. These are the facts I tell people. I say, listen, is your life in danger for where you are? Are you trying to escape for your life and do asylum, for example? And then, yeah, you should probably get out and come to the United States because, it's your safety. Secondly, are you an entrepreneur? Are there much better opportunities that you're going to take advantage of come to the United States than come? And this is not just for anybody that you think you're just going to get a better job, because unfortunately there's this perception for people that are coming here. They think that once they come to the United States, they'll be able to, just get easy money and everything's going to be easy. But the reality is in the United States, it's a treadmill. I hope you all know what a treadmill is. It's this thing you run on, you stay in place, but you keep running. And the U.S. is a treadmill that keeps getting faster and faster, but you still stay in your place. So no matter how much money you will make, it's going to get more taxes, more expensive lifestyle, more costs, and more headache. So it's not like a lot of foreign countries where, although the standard of living may be lower, it's a more peaceful, relaxed way of life, regardless of what the political and social situation is. It's very difficult living in America. It's very, very, go, and you can't sleep, and you kind of have to keep running. So you got to prepare for that. You're going to really do something that's different. Third is if you have, your children and you want them to live a better life, which is great, because if you're above 30, honestly, if you're above 25, immigrating is very difficult. You got to be a very, 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 very strong person to be able to adjust to living in a new country at that age or older. And 25 is young, but it's still hard. I've seen it, and it's just the experiences I had. And then finally, if you're in love and you want to come, well, you got to do it. But don't take this situation lightly. It's a lot of work to be able to adjust to the American system, culture, lifestyle, costs, and everything like that. Many times people regret it and want to go back. It's not that easy, but the opportunities are there for people experiencing the need where they're running away because they need to save their lives, or they have that entrepreneurial or hard work instinct where America's system really allows you to grow. It's going away slowly but surely, but for now, it's still the best in the world. So let's go back to questions. I hope that information is a little helpful as a discussion I have with clients who sometimes aren't sure what they want to do. I guess we're at this hour. Let me just read off our raffle winner, Sonia Arroyo. Sonia, thank you so much for participating. Please take a screenshot of your phone so I can make sure that it was you that said the consultation request and it's your name, and then email it to me at info@jqklaw.com, and we'll take it from there. Ali has a question. Picking up from my last question, my son filed for me, so I will be okay even if my I-94 is expired. Yes, Ali. So if you're a U.S. citizen, you're considered an immediate relative. I'm sorry, not you're a citizen. If your son's a U.S. citizen, you're considered an immediate relative. Immediate relatives are parents of U.S. citizens, spouses of U.S. citizens, and minor children of U.S. citizens. So if you're one of these categories and you enter the United States lawfully, even if you overstayed, and even if you work without permission, as long as you didn't, claim to be a U.S. citizen and get a job or something like that, you can adjust status. There's an exception for this under the Immigration and Nationality Act, Section 245C2, I believe, where it says, if you're immediate relative category, then these overstays are okay. So I wouldn't be worried about that. It's not good that the lawyer said the thing in the wrong place, but hey, it happens. Luckily, your case is not going to be affected. It's just going to, delay things by, I don't know, a month or so. That's about it. So it is what it is. We have Rosiana asking, fingerprinting applied to my adjustment of status case 8 months ago, nothing else. Is this framing time still normal for our reality? Yeah, I mean, there's no timelines when it comes to anything with immigration. Some are faster, some are slower. The timelines we see online are not reliable. Timelines your friends had or someone, the same case. I have 5 cases I filed on February 24th, 2020. 2 of them got approved after 9 months. 2 of them got approved after 1 year, and 1 of them is still pending. So it's like, it is what it is. That 5th person who's still pending is very frustrated, very angry. I think I did something, same exact case as the other 4, but it's just inconsistent. Love asks, I-485 pending as a green card. I couldn't pay taxes jointly with my wife because I don't have a social security number, so she filed a single without me. So when I get my social, can I amend jointly with her after deadline? I'm worried. Yes, you can amend it, but you should just talk to accountant. You could file jointly with your spouse. There's ways to do this. Most accountants probably don't know it from my experience, but you could have filed jointly with your wife and taken advantage of lower tax brackets as well, pay a little bit less taxes. But yeah, you can always amend later, but just, compensate and it's better to amend and submit it because later on for your I-751, it's good to have joint tax returns, but there's other ways to show your relationship. Olga asks, my husband had an interview at the beginning of February. He was refused for further investigation. It's now over 3 months and we have not heard an answer. What is the longest NBC will hold the passport? Well, the National Visa Center won't hold anything. It's the embassy which will do it. And sometimes they forget to send the passport back. If you need it, you just tell them, hey, send the passport back. When it comes to investigations, I mean, that's pretty messed up. So we'll have to see what happens. Ali says, hi, John. This is Ali. We spoke on May 3rd. I just got my case number for F2A with IOE number. Well, wonderful, Ali. It was good speaking with you. Let's go get the case number, F2A. Hopefully it processes fast. I have F2A is a spouse of a green card holder petition. I've seen these recently take 1.5 years, and I've seen it take 3 months. So if people tell me how long is my case going to take, who knows? But hopefully you got one of the fast ones that get up and running, and you could get the National Visa Center processing going soon. Sonia says, thank you so much. I didn't see my name to take the screenshot. I don't see my name. Sonia, just try to go back to your comment, but if you've already passed, just try to, take a screenshot so whatever app you're using has your name on it and send that my way. Should be fine. Hillary asked, USCIS responded to I-130 with the request for 2 passport photos. What happens after we send it? Probably you get approved. I mean, if they wanted more documents and more stuff, they probably would ask for it. So if you're just the passport photos, that's good. You definitely got to send those for a marriage case with the original application to avoid this kind of stuff. But you're probably getting approved, but I don't know. I mean, at the end of the day, they could do whatever they want to do. But I'm optimistic that more likely than not, that it's going to be fine. Ali Shay follows up. I just got my case number. Now, the question I ask is, when you do an IOE, when a receipt number comes and says IOE, what does that mean? Is it faster? No. IOE is just a term they use for electronic filings. Since everything is being sent to become electronic, even if you're a paper filer, that just make an IOE code at the beginning of your receipt number. Doesn't mean anything. And what service center? You look at the bottom left of your receipt, it'll say the service center, but sometimes they'll change the service center without even telling you. So none of that matters. I know you want to check USCIS.gov and see what service center, how long they're taking time, all this kind of stuff, but it just doesn't make a difference. You just gotta wait. Now, a quick reminder for those speaking of marriage cases, the Ultimate Marriage Green Card Guide, my free guide, it's the best one out there. I could really say that. It's free to download at marriageimmigrationlaw.com. Definitely check it out. You're going to see it and be like, damn, I can't believe this attorney just gave away all this information in this organized fashion, all these tips and addendums that are helpful. You'll really enjoy it. You'll think very highly of me. So that's how I wanted people to know. If you can't afford a lawyer, if you just don't have access, I think this guide will really help you better understand what's going on, so you go in with your eyes wide open. If you do end up talking with some lawyers to see what you get opinion on them, you know what's going on beforehand. So if they're trying to lie to you, or if they don't know what they're talking about, you could quickly tell based on that ebook. Levi asks, I just filed my F2A on October 26, 2020. Still no response. It just says being currently processed. Yeah, just gotta wait. Last reminder that we are going to be announcing our free consultation giveaway in 5 minutes. If you're interested in getting a free 15-minute consultation, like, comment, and that you want a consultation, and subscribe to any channel that you're watching this on Facebook, link to Twitter, whatever you are watching, not Twitter, but my associate will be naming a name, and I'll announce it in 5 minutes before we go off. So Harry M asks, can we expedite the I-485 green card application based on interest on joining U.S. Army, because my recruiter need my green card owner to join it? You can always give it a shot. Probably not. They're so backed up. They're not really open to expediting much. But Harry, just give it a shot. Why not? Contact the 1-800 number. Let them know what's up and give it a shot. Who knows? It might work. Luis says, hi, John. I applied for my I-765. That's an EAD, a work permit, on January 6, 2021, based on approved VAWA. Requested expedite through writing. Do they typically respond to such requests at Vermont Service Center? You shouldn't do an expedite by written request. You should call them up. For VAWA, Vermont Service Center, it's hard to call them up because there's some sort of security kind of stuff where for VAWA cases, they want to keep the cases private. But I don't typically send it in written request. They usually, from my experience, when I write an expedite request, they don't pay attention to it. I think they don't even look at it. So you got to call them up first and set it up through the call line. That's a better way to go. Canada says, for biometrics for H4, is applicable for previous filing or current filing? Your question is not clear, Kana, but they just said they're not going to do biometrics for H4s anymore, at least it's paused, so that should be it for there. Hilary follows up, my husband is in Mexico, and we are waiting for a response from USCIS. Does it affect if he is not in the United States? No, it doesn't. That's just, you're just having an I-130 pending. So hopefully you mark that you want consular processing so that you don't have to do an I-824 we talked about earlier. But I got to see your case to tell you directly, but I probably not. And thank you. You're saying your amazing information. Your information is so helpful. Thank you, Hillary, so much. Thank you everyone who's watching. If you enjoyed the questions, I appreciate it if you just go to Google, type in JQK Law. That's my law firm. And on the Google, review kind of stuff, leave a 5-star. You don't have to say anything, write anything. Just leave 5-star. It really helps out my business. I really appreciate it. A quick reminder about timelines. Right now, I don't have any answers about how long things are going to take and when the embassies are going to open up, all this kind of stuff. I don't have that, but I will be announcing the winner of the free 15-minute consultation in 2 or 3 minutes. So leave your comments, likes, and all that kind of stuff. And, my assistant will be choosing one person, and the other person will be named in 2 or 3 minutes. Chapman says, how long does background check take on I-485 case? Some cases it takes 30 seconds. Some cases it takes a year. So it just depends on the case. There's no fixed time on anything, and no fixed time on. There's maybe 1 out of 1,000 things in immigration that there's a fixed time on. The rest of them, you just got to be patient. Normally, it's pretty quick, and normally it's just a system. They just run your name through, your fingerprints through, and these computers will do it. But computers break down. Your name might match someone else's. There's a fingerprint that looks like someone else's, so you got to do investigations. There's a lot of things that are going on there. There's no fixed time that I can say or anyone can say about any case when it comes to background checks or internal processing for the immigration system. All right, so with that, we're about to end it. We'll take 1 or 2 last questions, and we're going to announce the winner of the third winner of a free 15-minute consultation. Thank you so much for everyone who's been listening, watching. It's been great. So, Hillary, you were so nice with your kind words. You've been our raffle winner. It's really H.Hillary22. You got the I-130 case. Your spouse is in Mexico. Just email me. Take a screenshot of your profile so I know that account was yours. Email it to me at info@jqqlaw.com. And what I'll do is schedule a video consultation. We'll talk about your thoughts and issues that you have with your kid, and we'll take it from, not with your kid, with your case. And we'll take it from there. And Chaplain says, thank you. Thank you as well, Chaplain. Appreciate that. So with that, everybody, we're done for today. Thank you all for joining. We'll be back next Wednesday, 5 p.m. Pacific time to take the general questions by U.S. immigration. Hopefully I helped out a couple people get a better idea of what's going on. And our 3 raffle winners going to have their free consultations the next probably next week, because this week's already stuffed full of consultation times. But we'll see. We'll be connecting soon. Thank you, everyone. God bless. Be safe. And wish you all the best till next week. Bye-bye.